of obstruction or retaliation, a third-degree felony. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. ECCR 0895. And Mr. Douglas, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 18th of 2025 for the offense of obstruction or retaliation, a third-degree felony. And that was a 3-year deferred probation. Is that correct? And this motion alleges that you violated your probation in count 1 only by failing to act in a courteous and professional manner, by incurring 3 new incident reports while housed at the Jefferson County Jail, including a physical altercation with another inmate on November 29th, 2025. Which was the same date of your last hearing. And so, is that true or not true?
True.
Did you enter your plea of true to count 1 freely and voluntarily?
Yes, ma'am.
And because it's actually true?
Yes.
So you never even made it.
I know. That's just, and I guess once you did that, you decided, screw it, I'm gonna do whatever I want because I already know I'm gonna get in trouble because you've been acting like an absolute fool in our jail. I'm not sure 4 years is enough. I need to think about this for a minute. I mean, is it really that hard to follow the rules?
No.
You didn't want to get out? You did? You got a problem with showing yourself while masturbating to the female officers out there, don't you? You don't?
Ain't got no problem.
You don't have a problem? You just like to do it and you think that's cool to do that in front of them? Even though you know you're going to get written up and go to prison for that? Was that worth it?
No.
Have a seat in the jury box. I'm not sure that I'm going to accept this agreement. All right. So just for the record, and I've gone back to review the pre-sentence report just to remind myself of what was in that and kind of what got us where we are now. And Mr. Douglas, I hate this because I really, really, really wanted you to succeed. I really did. I wanted you to be able to go to ISF. But I can't not stick to my word. I told probation when you were here. I told you when you were here. No more incident reports before ISF or you're not even going to make it. And it has been 1, 2, 3, 4, 6, 7. What day were we here? Dozens, at least. The sentence date was supposed to be, the sentence date was November 18th. So since November 18th. You've been caught with looks like kind of a makeshift tattoo needle. We've got 1.
At the heart of the hearing, the atmosphere in the courtroom shifts as Judge Raquel West delivers a firm and deeply critical confrontation, focusing on Mr. Douglas's repeated misconduct while in custody. She carefully walks through his disciplinary record, emphasizing that this is not a case of 1 or 2 isolated mistakes, but a consistent pattern of disruptive and inappropriate behavior that raises serious concerns about his ability to comply with any form of supervision. The judge highlights multiple incident reports in detail, including the physical altercation with another inmate, possession of contraband like a makeshift tattoo needle, and the troubling allegations of spraying disinfectant on others, actions that reflect both poor judgment and a disregard for the safety of those around him. What intensifies the moment further is the judge's strong reaction to the reports of indecent exposure and repeated inappropriate conduct toward female officers. Her tone becomes sharper and more personal, signaling that these actions cross a line from general misconduct into behavior that is both unacceptable and deeply disrespectful. She makes it clear that such conduct not only violates jail rules but also undermines any argument that the defendant deserves another chance at leniency. This portion of the hearing serves as a critical turning point, where the judge's patience appears to wear thin, and the weight of the defendant's actions becomes impossible to ignore. It is here that the courtroom fully recognizes that the outcome is no longer just about technical violations of probation, but about a broader failure to demonstrate accountability, self-control, and respect for the law.
2, 3, 4 or 5 at least times when you have been exposing yourself while masturbating to the officers, spraying other inmates with disinfectant spray, horseplaying, smoking. I mean, it's just,
Judge, I certainly understand your thoughts about it not being enough time, especially with the incident reports you're having a problem with on all these people in the jail.
no, I think I'm going to go along with what you guys have agreed to. I just wanted some time to look at it. I'm just reminding myself of all, I mean, the fact that you got this in the first place, because we went through, I have it all marked off on this PSI, your juvenile history and the opportunity you were given now that you're an adult to change your life and just follow the simple rules. So, I am going to, let's see. So I have, documents here on this tablet that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I go along with this agreement, that you're waiving any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Douglas is not competent?
No, Your Honor.
All right, Mr. Douglas, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence at this time to find you guilty. Right, something wrong. Find you guilty of obstruction or retaliation, a 3rd-degree felony. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. And so today, just Mr. Douglas, just because you got time today does not mean that you still can't do better and change your life. Better you act in prison, the sooner you're going to make parole. The sooner you do that, you can get out, hopefully follow the rules and have the best life you can. You get in TDC and act like you've been acting in our jail, you're going to end up doing the whole 4 years. But you're eligible for parole in less than 2. In about 1.5 years, you're eligible for parole. And that's going to be 100% up to you. And I can assure you, you're not going to get it if you keep acting like this. All right?
As the hearing draws to a close, Judge Raquel West delivers a conclusion that feels both decisive and cautionary, reinforcing the seriousness of everything that has unfolded in the courtroom. By honoring the agreed-upon 4-year sentence, she signals that while the court is willing to follow negotiated terms, it will not overlook the pattern of behavior that led to this outcome. Her words carry a clear weight. This is not just about punishment, but about the consequences of repeatedly ignoring opportunities to correct one's actions. The judge underscores that Mr. Douglas's situation is the direct result of his own decisions, making it evident that the court's patience has limits when faced with continuous violations and disrespectful conduct. At the same time, the closing moments are not entirely without a forward-looking perspective. Judge West acknowledges that the defendant will have a chance at parole in the future, but she frames it as a privilege that must be earned through genuine change, discipline, and respect for authority. Her final remarks serve as both a warning and a challenge, pointing out that the system can offer opportunities, but it cannot force transformation. The responsibility now rests entirely on Mr. Douglas to prove whether he is capable of learning from his mistakes. The hearing ends on this note of stark reality, leaving a lasting impression that this moment could either mark another step in a cycle of poor choices or become the turning point that defines a different path forward.